Good morning, everyone. It is a great pleasure that TMA Brazil welcomes you all to the International Coffee Cross-Border Insolvency Brazil at the Crossroads-US, China, and Offshore. This event is sponsored by Kobre and Kim. And before starting off, on behalf of TMA Brazil, I would like to thank the institutional sponsors, BTG Pactual, Galdino Pimenta Takemi Ayubi Salgueiro Rezende de Almeida, Invista, Mega Leilões, TWK Advogados e Márcio Guimarães Advogados, Washington Pimentel Advocacia. And now I hand over the word to Vitor Clementino.
Hello. Hello. Good morning, everyone. Welcome. It's truly a pleasure to see so many familiar faces in the audience. I want to begin by thanking TMA for organizing this event. Grazi, Maju, and Rafael. We've seen the amount of effort you guys put into this, so we really appreciate it. And on behalf of the team at Kobre and Kim, we are very honored to sponsor this event, where we'll discuss key issues surrounding cross-border insolvency and asset recovery. This event reflects our firm's continued commitment to the region, and especially Brazil. As some of you know, Kobre and Kim opened its office in São Paulo in 2019, and since then, the São Paulo office has been instrumental in consolidating our presence in Latin America. The region today not only generates a significant portion of our cross-border work, but also plays a key role in the strategies we deploy globally for our clients. In recent years in Latin America, what we've been seeing is a surge in distressed debt that's driven by a variety of factors such as global economic and political uncertainty, high interest rates, and inflation. At the same time, we've been seeing major reforms in bankruptcy and insolvency laws across South America, including Brazil and in Chile, and also a steady pipeline of complex cross-border restructuring cases such as, for example, Gol, OEC, Intercement, Unigel, just to mention a few recent cases. We've also recently seen the Americanas case, which involved the largest accounting fraud in Brazil's history, with a judicial organization in Brazil and a companion Chapter 15 in New York. And against that backdrop, at Kobre and Kim, we are seeing creditors and investors, both inside and outside Brazil, realizing that they need to take a more global approach to claim monetization and asset recovery. Local strategies are often no longer enough. Clients are increasingly focused on taking actions across multiple jurisdictions. The US has always been and continues to be an obvious choice given the substantial links with Latin American countries. But our Cayman and BVI offices have been busy with more and more questions from clients looking to understand how to pursue remedies in offshore jurisdictions, where many shareholders of distressed companies hold their wealth. We are also witnessing growing Chinese investment in Brazil. And as some of those investments go sour, we have been handling questions on how to navigate such situations together with our colleagues in Asia in our offices in Shanghai and Hong Kong. Today, we are joined by seasoned professionals with extensive experience in these matters and are confident that this will be an engaging and insightful day of discussions. We will explore cross-border insolvency and asset recovery, focusing on the interplay between Brazil, the US, China, and offshore jurisdictions. The event will feature 3 panels. The first panel, moderated by Fábio Rosas, from Lefosse Advogados, will discuss cross-border insolvency and asset recovery in Brazil and Greater China. Panel 2, led by Marcos Costa, from Machado Meyer, will cover offshore liquidations as tools in cross-border investigations and asset recovery. Finally, panel 3, led by Luis Fernando Saradiotto, from Journey Capital and the chairman of TMA Brazil, will focus on US Chapter 11 and Chapter 15 bankruptcy tools from an asset recovery perspective. At the end of each panel, we're going to have some time for Q&A. So with that, I'll hand over to Fábio Rosas to kick off our first panel. Thank you very much. I hope you all enjoyed the event.
Thanks for invitation. Kobre and King and TMA Brazil. Here. Thanks, everybody. Good morning. We prepared and I believe an exciting discussion about the topic, some more interactive discussions rather than personal or individual exposure. Although the matters that we're gonna explore here are related, but they are very specific topics related to insolvency and enforcement proceedings through cross-border and internationally and the Brazilian experience. We have in our panel John Hamm, is a cross-border disputes and contentions restructuring lawyer based in Hong Kong. He focuses on representing creditors and debtors in matters involving Greater China, offshore jurisdictions, and the Asia-Pacific region. Has acted as leading counsel in a wide range of cross-border campaigns involving bonds, loans, judgments, and awards exceeding billions of dollars. That's important in the word. Billions are good. On behalf, distress. That's why we're here trying to learn about the $1 billion case. But it's true. Distressed debt investors, borrowers, and issuers. Institutional investors, states and corporations, a long experience. Thank you, John, and thanks Kobre and King for inviting us and having the opportunity to discuss very interesting topics and learned with international experience from John. Guilherme Amaral, in my left, is founding partner and currently CEO of Souto Correa Advogados. Focus his practice on both domestic and international arbitration. Luciana Celidonio, my left, partner in BMA Advogados, restructuring and insolvency and dispute resolution practice areas. And Julia is, last but not least, partner in bankruptcy and restructuring practice of Veirano Advogados. Let's start. The idea is having a quite, let's say, a quite overview on each of the topics related to insolvency, cross-border, and enforcement proceedings. We thought it was pretty interesting because at the end they are pretty much related, especially from the focus and specifically on the focus of international investors, as well as in Brazil, and how to deal with the experience abroad, especially in our focus here in Hong Kong and China. So I will start, and the idea is having a link in what would be the instruments, challenges, and solutions and potential solutions when we are facing enforcement proceedings, credit enforcement proceedings, insolvency, formal proceedings or informal proceedings, or the strategy among in an insolvency situation, and also the cultural and pretty let's say influential cultural differences that we used to face when we are working on cross-border cases, international disputes, international cases, arbitration, and as a consequence, the enforcement on awards and insolvency problems that may affect more than one country and more than one institution or international entities. So let's start with John. And I'll ask John first to make a kind of a summary for us on the instruments available for enforcement in Greater China, in Hong Kong, and how we may deal with the enforcement proceedings there, and how the legal system may treat either the enforcement proceedings and the consequences that we're going to explore more later.
Yep. Thank you, Fábio, and thank you, TMA, for hosting us. I'll just give a quick overview because I realize people may not be that familiar with the legal systems in mainland China. But we talked about a little bit a scenario where this may come up with Brazilian parties dealing with Chinese parties. Something happens, and then there's a debtor based in mainland China, primarily assets there. The holding structures may be elsewhere. We're talking about offshore. It's very common, and then some kind of listed entity in Hong Kong, which is remains the primary capital market for mainland China. So in this situation, the puzzle that everyone is trying to solve in the Holy Grail is recovering assets within mainland China. And so the question is, how do you do that? The obstacle to this is that mainland China does not recognize a lot of procedures and legal process from elsewhere. We'll talk about it a little bit later, but this includes liquidators from common law jurisdictions, court-appointed receivers, and also judgments in many cases. There's exceptions, but so for example, we work a lot with offshore USD bonds. Those are governed by New York law, and generally speaking, a New York judgment is not recognizable in mainland China. And so the question is, how do you reach these assets? And I would say that if you look at the international distressed debt markets, priced into that is an assumption that it's not accessible, basically. And so for those who can try to solve this puzzle, there's a lot of opportunity. So there's a couple of different things to note with Hong Kong as a gateway jurisdiction. So Hong Kong is still governed by English common law principles. The English common law from England and Wales, Supreme Court is not binding, but the judges are English common law educated, and the courts and the decisions are still persuasive authority. Mainland China is totally different. It's a code-based jurisdiction. There's no discovery. 100% different. So Hong Kong is the special administrative region that's preserved the legal system from before the handover in 1997. But what makes it special, especially compared to some of the regional jurisdictions that we think of that may be similar, like Singapore, is that it has many treaties, essentially, with mainland China, the special arrangements that make this a little bit more practical from a creditor's point of view, and that's what the perspective that we're trying to take. So in the past, there has been a mutual recognition arrangement between mainland and Hong Kong, so that Hong Kong judgments essentially based on a breach of contract, where there's an exclusive jurisdiction clause selecting Hong Kong courts, are enforceable in mainland China through a very quick recognition procedure. There's interim relief. But just last year, that's been broadened to include any decisions outside of liquidations and outside of matrimonial judgments. And it's also been broadened beyond money judgments. So if you say, looking forward, Brazilian company doing business with a Chinese company, writes into the contract Hong Kong courts or Hong Kong International Arbitration Forum selection, those judgments, those disputes that result in a money judgment have always been enforceable. But what's really interesting, and I think is somewhat untested territory, is the takeover of onshore companies, which we'll talk about a little bit. So if you have a Hong Kong decision declaring that a creditor is entitled to the shares of a mainland Chinese court judgment, under the text of this law, it's actually recognizable. And so there's more and more options, I think, for creditors that are dealing with adversaries in mainland China. So it's quite ironic because one of the questions we get all the time is whether Hong Kong is still a impartial forum, because obviously there's been a lot of political developments in the last 5 years, and there's a perception that if you're adverse to a state-owned enterprise or a major contributor to a local economy, that maybe there should be some kind of bias. But if you actually dig into the particularity of it, it's very tactically advantageous still for a Brazilian party dealing with a mainland Chinese party to choose Hong Kong arbitration or Hong Kong court as the forum. There's preservation arrangements, very low bonding requirement for injunctions in support of Hong Kong litigation. and so on. So it still has this kind of special status. We're seeing this more and more with various countries, including Brazil. Thank you.
Yeah, very nice. Interesting to hear that it is a quite developed and quite opportunistic also measures and instruments to be used. I will jump to Guilherme and starting discussing first arbitration enforcement and how enforcement proceedings could be dealt with and our experience in Brazil on international arbitration, and that will be interesting to hear first our view, Guilherme's view, and debate a little bit about how to deal with insolvency or how to pursue assets, how to enforce, and what would be the experiences that in Brazil and cross-border arbitration. Guilherme, please.
Thank you, Fábio. And first of all, I'd like to thank Kobre and Kim for the. Do you hear me well, or do you need a microphone? Okay. A microphone. Okay. That's you're my boss. Okay. Thank you. Thank you. I'd like to thank Kobre and Kim for the kind invitation and TMA for putting this event together. I have to, first of all, to make a full disclosure, I'm feeling like a fish out of the water here. I'm the only one in the stellar panel who's not an expert in insolvency in bankruptcy. I'm an arbitrator, practice arbitration, both as an arbitrator as a counsel. So my goal here is try not to get in the way of the experts and not bore you, and maybe learn something in the process. Okay, but I'll speak a little bit about this clash between arbitration and bankruptcy and insolvency. When you think of arbitration, you think of a private proceeding, a private process. You deal with private interests of only of the parties. No third party has any interest involved. You deal with secrecy, with confidentiality. And when you think of insolvency and bankruptcy, it's quite the opposite. You're dealing with multiple interests, interests of the creditors, interests of the company, of the employees of the company. So when these two worlds collide, we have a lot of issues that can be raised and can sometimes make harder for an arbitral award to be enforced, or for both of these procedures to live together. So I'll try to explain some of the impacts of bankruptcy and insolvency proceedings on arbitration under three perspectives. So the first one, what is the impact of these insolvency proceedings on arbitration agreements? So when you don't have an arbitration going on, what happens with the contract that has an arbitration clause? Secondly, what happens when you have an arbitration proceeding ongoing and you have the bankruptcy or insolvency proceeding started? And finally, the impact of these proceedings, insolvency and bankruptcy, on arbitral awards. So that's basically the three perspectives I'm gonna talk about, and I try to draw a comparison between Brazilian and Chinese law. Of course, if you have any problems involving Chinese law, you should look for Kobre and Kim in Shanghai or in Hong Kong. I'm not an expert also on Chinese law, but I'll try to make the best of it. So first of all, the impact on arbitral agreements. In Brazil, if you have an insolvency proceeding, started judicial recovery, or even a declaration of bankruptcy, it doesn't impact the arbitration agreement. So you can start an arbitration even if there is a insolvency proceeding ongoing. And that is provided by Article 6, Paragraph 9 of the Brazilian bankruptcy law. In China, there is a judicial interpretation of the People's Supreme Court, which is the highest court in China. It's just like our Supreme STF in Brazil. And there's a judicial interpretation which is like a binding precedent that states that before moving to, let's say, to file a proof of claim, let's take an arbitral award issued in Brazil and want to take to a recovery proceeding or an insolvency proceeding in China, you should first go to the bankruptcy court and ask and present it as a proof of claim. And sorry, if you don't have an award, if you have an arbitration agreement, you shouldn't start an arbitration. You should first go to the bankruptcy court and see whether there is an actual dispute to be brought to arbitration. Because if the debtor and the court and the judicial administrator recognize that there wouldn't be any dispute, so you wouldn't need to file for an arbitration. That's the judicial interpretation of the People's Supreme Court. There are, however, some questions about the sanctions for not complying with that requirement, because the People's Supreme Court hasn't evolved on that, hasn't regulated the sanctions for not complying. So if you have, for instance, if you want to start an arbitration in Brazil against a Chinese company who is under an insolvency proceeding in China, you should know that there is this interpretation of the Supreme Court there that you should first bring the claim to the court. But it's unlikely that if you have an arbitral award in Brazil, it is unlikely that it will not be recognized in China, because China is a signatory of the New York Convention, so it will likely give a lot of prestige to an award in Brazil, which is a marked difference between what John just said about other types of decisions, judicial decisions. When it comes to arbitration, China is a very friendly country. There's another impact on arbitral agreements which concerns the principle of separability. So in Brazil, if you have, even if the main contract is nullified, the arbitration agreement still lives on because it's considered a separate agreement from the main contract. In China, China recognizes the same principle. However, the administrator in China may ask the court to nullify the transactions made by the debtor in some circumstances, mostly when there is an unreasonable price for the transaction, or in cases in which the payment under the transaction benefits only the creditor and not the debtor. In those cases, there's sometimes the administrator will ask the court to nullify the agreement, and if that happens, scholars in China consider that this dispute would be non-arbitrable. So that's different from what happens in Brazil. So in China, if you have that nullification in the bankruptcy court, the dispute will be considered non-arbitrable by a tribunal in Brazil, for instance. So moving on to the impact on arbitral proceedings. Again, in Brazil, if you have an ongoing arbitration, the arbitration is not going to be suspended by the beginning of a bankruptcy proceeding, be it in Brazil, be it in China. In the UNCITRAL model law, I think Julia will talk more about that, but in Article 20 of the UNCITRAL model law, there is a provision that states that every claim against the debtor will be stayed, but that provision is optional, so some countries can take a more flexible approach, and that is the case of Brazil, who took a much more flexible approach, allowing, for instance, arbitrations to go on despite the commencement of an insolvency proceeding. In China, the insolvency proceeding, the bankruptcy proceeding, determines that if you have an arbitration ongoing, the arbitration will be suspended until the judicial administrator takes over the assets of the debtor. In that case, the arbitration can move on, and it's risky not to follow that procedure. If you don't follow that procedure, if you don't suspend the arbitration going on, there might be a risk that the award is not going to be enforced later on when you bring it to China. In Brazil, another interesting feature is that the arbitrator may ask the court, the bankruptcy court, to reserve the amount to cover the amount that is being discussed in the dispute. In China, there's a similar provision in the enterprise bankruptcy law, Article 119, in which the administrator reserves the share that will be destined for that dispute that is going on outside of the bankruptcy courts, for instance, an arbitral dispute. However, this reservation of share lasts for 2 years after the bankruptcy is terminated. So once the bankruptcy terminates, you have 2 years of reserved share, and if you don't have an arbitral award until then this share will be distributed among the other creditors. And finally, the impact on arbitral awards. So both Brazil and China are signatories of the New York Convention, and this is very, very important. So if you have a dispute against or a contract with a Chinese counterparty, arbitration is definitely the way to go when it comes to dispute resolution. I know I'm selling my my practice here, but that is absolutely true. You learn it from what John just said, and so this convention is really respected in China. Just for you to know, there is a study on the enforcement of arbitral awards in China. 91% of foreign arbitral awards are fully recognized and enforced in China. 7% are partially recognized, and only 2% are denied recognition. So it's a arbitration-friendly jurisdictions, despite what people say about it. And so what we have here in arbitral awards is that in Brazil, you must have the award, the foreign award, recognized in the Superior Court of Justice in order to present it as proof of claim in an insolvency proceeding. You cannot go directly to the bankruptcy court. You have to introduce the award in Brazil through the Superior Court of Justice. In China, there is a reverse situation. The court that has jurisdiction over the recognition of award is the lower court, and in that case, the bankruptcy court. If the court denies recognition of the award, there is an immediate appeal to the higher court, and if the higher court denies recognition, you would still be able to go to the Supreme People's Court of China. So that's what they call reporting system, and that's basically destined to give a lot of priority and a lot of prestige to foreign awards. And as I mentioned, it works well because you have a high rate of enforcement. In China, the judicial administrator can apply for the bankruptcy court to revoke or not enforce an award in case there is evidence that the creditor and the debtor maliciously fabricated the claim. So in cases of fraud, the bankruptcy court can deny enforcement of an arbitral award. It doesn't happen in Brazil with a foreign award. If you have a foreign award, let's say an award issued in mainland China, you want to enforce it in Brazil, you go through the Superior Court of Justice, that's where you have to challenge the award. Once the Superior Court of Justice recognizes the award, it will be enforced, it becomes res judicata, and there's no way a bankruptcy court can deny its enforcement. So I'll stop there. There's not much time, and I'm sure that Luciana now may talk a little bit about some clashes between, when she comments on my answers, she's probably going to be able to talk about some clashes between arbitrators and courts. Just as a highlight, you probably know that despite everything I've just said, there's a constant clash between bankruptcy courts and arbitral tribunals. That's not something you can deal with in 5 to 7 minutes. That's a topic for a longer discussion. But I just would like to highlight that point, and maybe my colleagues would like to comment on that as well. Thank you so much.
Nice, thank you. Guilherme, those numbers that you mentioned, I'm just curious, before Luciana, those numbers are the recognitions in China?
Yes, yes.
And in Brazil, just to compare, do you have those numbers?
I don't have the number, the exact number in Brazil. It's very high rate of recognition in Brazil as well. Brazil is considered a friendly jurisdiction. We just had 1 week ago, an interesting precedent from the Superior Court of Justice. I was lucky to be the attorney in charge of the case, but the Superior Court of Justice basically said that arbitration is autonomous to the Civil Procedure Code, and therefore gave a lot of prestige to arbitration as well. So Superior Court of Justice is a really friendly jurisdiction to arbitration, and most of the cases that go there get recognized. However, it takes a lot of time, sometimes 18 months, even if it's not challenged, because the court is clogged with cases. So that's our main problem in Brazil, but we have the same problem in China. I mean, time is of the essence of any judicial process.
Okay, thank you, Luciana. Well, after I'll have a question, if we have a kind of Alexandre de Moraes as well in China, to John, just to know exactly how the system, and it seems to be pretty much democratic from our point of view, our Western point of view, no, and pretty much, open and democratic. Probably they won't have any Alexandre de Moraes there. Luciana, please, just a bad joke in the morning. No? Luciana, please, give us our thoughts and a very interesting comparison. No, how enforcement could be effective, and we're gonna talk a little bit more about the effectiveness of the award and having the enforcement and having the solution for a problem, even in insolvency situations.
Well, hello, good morning. First, I would like to thank TMA Brazil and Kobre for the invitation and for the event. I just want to make first a comment on what Guilherme said. He mentioned that the commencement of an insolvency proceeding should not interfere in the commencement of an arbitration, right? But I just want to mention that according to Brazilian case law, some matters are, the judge of the JR court has exclusive jurisdiction to decide on some matters, such as what assets are essential to the company, what credits are subject or not to the proceeding. So even though the commencement of an insolvency proceeding should not interfere in the course of an arbitration proceeding, sometimes there is a thin line between who has jurisdiction to decide some matters. So I think just an explanation to say that the line is not so clear, right? You should continue with the arbitration, but sometimes you have some matters that are that the law decide that only the JR court can decide. Well, my topic here is kind of unrelated to the other ones because we have audience that is not Brazilian. So I'm talking a little bit about the requirements for piercing the corporate veil, considering that we have like foreign audience in Brazil. So what are the requirements for piercing the corporate veil in Brazil? You know, I think it's pretty basics, but let's go. I think we know that it's abuse of legal entity, right? Characterized by deviation of purpose and fraud, and also commingling of assets. Historically, Brazilian courts have been very not applied the piercing of the corporate veil in a non-exceptional way, right? So it was really common to obtain the piercing of the corporate veil based on low requirements such as be part of the same economic group, have common partners, have same address, no formal dissolution of the company. But then we had an amendment of the law in 2019, and which introduced some new requirements for piercing the corporate veil in Brazil. And it restricted the effects of the piercing of the corporate veil to those directly or indirectly benefit from the deviation of the purpose or commingling of assets. And the law also stated that it is the mere fact that the companies belong to the same economic group is not enough to grant a request for piercing the corporate veil. So I think that nowadays it's more, we should pay attention because it's not so easy to get the piercing the corporate veil like it should be, in my opinion. And if you choose, because when you have like cross-border issues, it was common to pick Brazil to get the award, deciding for the piercing the corporate veil, and take this award to other jurisdictions, right? And this was really common. And I think we still have a lower test or a test that is like less restricted to apply for piercing the corporate veil than other jurisdictions. But now the case law is evolving, so I think we should pay attention on that. And another thing that is important is that case law on the topic decide that the court should not impose legal fees in incidental proceedings for the piercing the corporate veil. But recently there was a decision from the Superior Court of Justice, I think it's from September 2023, deciding that you should impose legal fees on this kind of incidental proceeding when the proceeding is rejected. So I would say that it's no longer a free ride to file an incidental proceeding in order to obtain the piercing the corporate veil in Brazil.
I'm always in favor of legal fees. That's a key point to hear, okay?
Yeah, me too.
No, okay, great. And getting back, the enforcement, it is related to the award that should be, at the end of the day, satisfied. And then if we have a situation or problematic enforcement proceeding, how we may deal with that, especially in insolvency and cross-border and insolvency situations. I'll make the same questions for you both, starting with Julia. How would be the strategies to get a deal to being satisfied, to have an award, an enforcement award, even with the this disregard of legal entities or enforcement of foreign entities? And we had experiences in the past. I'll ask Julia to also to comment. Few experiences in Brazil, although even in the past, we didn't have more instruments to recognition, formal recognition of foreign proceedings, etc. But we had experience on foreign entities, legal entities, holding companies. I believe China and the region, Hong Kong, etc., uses a lot. Even in Cayman and in Bermuda and in the Caribbean offshores, right? And I'll ask John about that. But starting with Julia, how to deal with that and how would be the strategies to get satisfied, to get the award enforced?
Thank you, Fábio. Good morning to all. Thank you, TMA. Thank you, Kobre and Cam, for the invitation. It is such a pleasure to be here today with colleagues and professionals I admire so much. So John talked a little bit about how challenging it can be for receivers and liquidators to be recognized in China. And Guilherme, on the other hand, talked that it was mentioned that the Superior Court of Justice is doing good work, although a little bit, time-consuming and bureaucratic, but is doing a consistent work recognizing arbitral awards. When it comes to insolvency proceedings, particularly, the landscape in Brazil before the 2020 law reform was we didn't have a clear route to recognize insolvency foreign proceedings. We would go through the Superior Court of Justice, but the track record was not favorable, meaning that the Superior Court of Justice basically was of the opinion that recognizing a foreign insolvency proceeding in Brazil would offend the public policy of Brazil. So after, and that also created, let's say, a vacuum where corporate groups would file for reorganization proceedings in Brazil, so Chapter 11, and include foreign entities, foreign merely paper-holding companies that would issue a debt abroad merely to finance operations in Brazil. So after the 2020 law reform, effective in 21, Brazil substantially adopted the ancestral model law. And although the effectiveness is still relatively untested, we have a few cases, and I wanted to talk about particularly a case of an insolvency of a natural person, and I see André here in the audience. An insolvency of a natural person. It's a proceeding that is underway in Camboriú. And the courts, although is still pending a final ruling, the liquidator of a bankruptcy underway in Scotia filed a recognition proceeding so that the lower court in Camboriú would recognize the authority of the liquidator and then process the recognition proceeding to effectively seize and attach assets of the debtor, and they have been successful thus far. Even though it's still pending a final ruling, it is at the appeals level. The assets are frozen, and the creditors have been successful thus far. So that seems to be a good precedent, although we also have negative precedents where the courts understood that since Brazil does not include in our bankruptcy law the insolvency of a natural person, it would not be acceptable to process a recognition of a bankruptcy of a foreign of a natural person. So yeah, it's a good precedent, but still the jury is still out, let's say. And on the other two cases, I will briefly mention. So it was different. It was recognition proceedings filed by debtors seeking to have the assets of the company in Brazil protected against enforcement proceedings filed by creditors. So it was Pro-Safe Rigs. It was a shipping company filed in Rio de Janeiro, had a recognition accepted by the court, and then a stay granted to protect the assets. And Merck & Coffee, which is, I believe, well known by the audience. It was a case filed in Minas Gerais, and the debtor also sought a stay. The court granted, but some creditors holding certain types of collateral were deemed to be not impaired by the order. This is still a litigation that is still underway.
Yeah, thank you, Julia. When was this personal insolvency case that you mentioned in South?
It is recent. It is still pending a ruling, a final ruling. The first, the lower court granted, and it's still pending at appeals court in Santa Catarina.
And in Mercon case, just a parenthesis on that, it seems to be very well applied. The law, for the first time, the law fully recognized foreign proceeding, actually with the effects in Brazil, a stay, and it seems that the stay is not applicable for the entities that made the request, according to the Brazilian law. But it's okay. Yeah. We're gonna have a full panel to discuss that. John.
Yeah. So I'll talk about the other side of the coin, which is if it's a debtor in mainland China, and just as previewed, there's a very challenging environment for common law liquidators and common law receivers to be recognized there. And so you need to be quite tactical and strategic. Luciana had mentioned this, the idea of getting some relief in one jurisdiction and then using that as to leverage a circumvention, I suppose, of the obstacles in the second jurisdictions and an arbitrage of sorts. That's very important, I think, in mainland China. Because of this obstacle to reach the mainland Chinese assets of a debtor that a Brazilian entity might be dealing with. There's a couple of different ways to do it. So if you're dealing with a company that's listed in Hong Kong, which as often happens, there's a pilot scheme. And there's 3 cities within mainland China which will recognize a Hong Kong appointed liquidator, even if the company is incorporated elsewhere, offshore BVI Cayman, but it's listed in Hong Kong, Shenzhen, Xiamen, and Shanghai. And that affords the Hong Kong-based liquidator or receiver the full suite of Chinese onshore recognition, liquidator powers with discovery, recovery of assets, and so on. So that could be very powerful. The second is cross-border recognition of awards and judgments, which we've already spoken about. But what's really interesting is that even outside of these 3 cities, there's been a lot of less prominent takeover of Chinese companies through informal means, where a liquidator appointed elsewhere will just fire the board of directors, essentially, of a holding company, and then use their shareholder powers to pass resolutions to try to replace the board of the onshore mainland Chinese company. There's a couple, so you have to take this cross-border perspective, but there's some unique features in mainland China that make this particularly difficult. So the first is this concept called a company chop, which is akin to a power of attorney. And it's the seal. There's actually many. There's a company chop, a contract chop, legal chop, that have different designated powers. And physical possession of this item is extremely important. So even if you're fully vested with court powers outside of mainland China, you've got your resolutions in hand, sacking the board, you have to actually find this item. And We see all sorts of games related to this. We had a situation where we have break-ins all the time, where people actually literally go into the office and then steal the chop, and it's more effective than you would think, even though it's very crude. We've had situations where someone actually dug a tunnel in the facility and then snuck it out. We've had physical alterations, so if someone has gone to the bureau to replace the company chop and they've literally gone into a fight and then everyone gets arrested. And recently, just to highlight this, we had a situation where the chop was locked in a safe, and then the safe was with the first lien holder. Our client had the combination to the safe, the other side had the key, and it was being transported on a certain day. So actually the plan, in addition to the legal proceedings, was to intercept this like a nuclear football, basically to take possession. Ultimately, we did end up taking possession. There's also a concept of a legal representative. So a legal representative has personal liability for the company, but they're very hard to replace. And generally, it's someone that's very closely linked with the incumbent. Oftentimes, it's actually just a driver or some poor low-level employee, unfortunate low-level employee that's exposed to all of this liability risk, but really has very little to do with the day-to-day operation of the business. And they have to be kicked out, basically. And just to show you the practical difficulties of this, the rule was they had to sign the form allowing the new representative to come into place, and they would just refuse to sign it. So it's similar to hiding the company chop or pulling it out in a tunnel or something. It's actually quite effective, even though it's very crude. There's a change in the statute in July that said that signature is no longer needed, but we'll see in implementation how it turns out. So I think all of these things require a softer touch of looking at the individuals and then seeing if there's some sort of collateral leverage. Often they're not being compensated for all this high degree of risk. And so the devil's in the details very much, but it leads some interesting stories.
Very good. Thank you. Well, we are running out of time. We have a few minutes for questions, if you have any question for the panel. Any topic. I had just to give another example, and I had in Brazil a foreign client that asked me to take possession of and the seizure and attachment of assets that they were financing in Brazil. The foreign client asked me, Fábio, can we hire criminals to go after and to get the possession of, because in my country, usually we do that. So that's an example of how different, sometimes the cultures and the instruments and enforcement proceedings or solutions, or especially on liquidations. Liquidations are really tough and are really exceptional at the end of the day, no?
They bring out the best in people, right? Liquidations.
Exactly. Special people, special. That's not a coincidence that we are called special situations teams,
I actually just wanted to let you know, John, that if you need criminals in Brazil, we have a lot. No, just kidding. That's not why I asked the microphone. I actually wanted to ask if there is any difference in the perspective when you are dealing with state-owned companies. Because I think in Brazil, you're seeing a lot of state-owned Chinese companies, or companies at least controlled by the state entering the market. So it would be nice to hear from you if that changes the perspective on anything.
Good question. I will add, if I owe money to a state company in China, can I be arrested when I go to it? Because I have a friend who was arrested at the immigration because he was owing money for a state company in China.
Yeah.
So that's a good question. Thank you.
Yeah, I think it actually quite depends. So dealing with a state-owned enterprise or something that has a controlling share that's owned by a government, could be domestic, is just dealing with a completely non-commercial actor. So they're not going to respond to rational incentives the way that you would when you're dealing with another business. So sometimes you don't even have a counterparty to talk to. It's very bureaucratic. The lower level individuals are oftentimes covering up issues. Someone has gotten into a lot of trouble for getting them into this situation, and there is effectively no principle in some cases. Depending on the state-owned enterprise, the courts operate as an instrument of the broader government, unlike an independent judiciary in some cases. And so cases will not move forward. They will be consolidated in a single forum and then effectively stayed forever. So we know about these property developers that are quite famous, Evergrande, hundreds of billions of dollars in defaulted debt. There's very little possibility that any kind of collections proceedings in mainland China will work. And if you monitored when it was wound up by the company's judge in Hong Kong, the liquidator on the courthouse steps immediately after said, I don't plan to take any action within mainland China, which is very remarkable because it's a liquidator that's basically announced that they will conduct no liquidation. But I think it's a practical reality. It also creates risk, I think, if you're taking these measures and selling assets onshore. There's been cases with people who have been refused the right to exit China. There's someone, and this has been very widely discussed in the press, that's been there for over a year related to an asset sale. So people are very cautious about these things, I think understandably, when they're dealing with certain state-owned enterprises. In other cases, business as usual. It just depends, yeah.
Yeah, okay. Yeah, thank you very much. We are done, and Luciana would even, make a kind of a last comment as well on this regard and having, assets and attaching assets or personal involved in liquidation and insolvency. But we would like to thank a lot. Thanks, John and the panelists, Guilherme, Luciana, Julia and John, specifically John, gave us very interesting stories as well. And thanks Kobre and King, and thanks TMA. And applause for our team here, panel, very interesting. I learned a lot. I cannot be arrested in China. Yeah, you should call John, if you're gonna go to China.
Hello, everybody. I'd like to thank you, TMA and Kobre King, for the event and for the invite. I'm Marcos Costa, partner from Machado Meyer. We have here a panel, and I introduce all my colleagues here. Fabiana, partner at Transformation, Restructuring and Insolvency Department at Felsberg. Dave Griffin is a senior management director and established the FTI consulting practice in the Cayman Islands. He has more than 24 years experience, including 17 based in the Cayman Island and British Virgin Islands, during which time he has specialized in providing insolvency, restructuring, and other financial advisory service to offshore structures. Many of David's engagements involve formal appointment by the Cayman Island Court as official liquidator, provisional liquidator, or receiver. Also, Paulo Campana, partner at Campana Paca, based in São Paulo. He's a lawyer specializing in insolvency and restructuring. And finally, Peter Tyers-Smith. He's a partner at Kobre King, based in the firm's Cayman Island office, acting for court-appointed liquidators, receivers, as well as fund managers, general partners, and international investor over the past decade. Peter has led major litigation arising from multi-billion-dollar liquidations and receiverships proceeding in several offshore jurisdictions. His case invariably involved the most serious allegations of fraud, misconduct, and financial mismanagement. So we have here another panel of regarding offshore jurisdiction. And offshore jurisdiction, especially in Brazil, still carries that certain reputation that's local for frauds or local for misconduct, because it's a company abroad with a trustee there. So we have also mainly these doubts regarding offshore companies. But the question that we ask here in debate is this still prevailing, this measure, making offshore financial centers like Cayman and BVI, for example, impossible to recover assets or a place where frauds can be practiced? So this panel will discuss the liquidation process used in these frauds and misconduct cases as part of a cross-border investigation and assets recovered strategies, and how these can be used in Brazil and in Cayman and BVI to recover assets in liquidation proceedings. So we'll start here with Fabiana, and I'll ask her to give us an overview about the topic under the Brazilian context.
Thank you, Marcos. It's working. Sorry. Thank you, Marcos. First, I'd like to thank Kobre and Kim for promoting this debate. I think it's a very appropriate topic, considering what we have been facing in Brazil regarding fraudulent conveyance and insolvency right now. And also TMA for the invitation, and Graziella for the organization, always impeccable. Moving on to our topic, and I must say that I was able to gather and to track some alarming data over this week, and I need to confess that I didn't have an idea about the numbers involved here. And we are talking about the low percentage of creditors' recovery in bankruptcy liquidations, in RJ proceedings, which is our Chapter 11, and also in enforcement proceedings in Brazil. And so a study conducted by the Observatório of Insolvência, which is our insolvency observer, dated of 2022, pointed out that creditors recover approximately 6.1% of their claims in Brazilian liquidation proceedings. That is amazingly low. In 2023, I also had access to a master's degree study argued with FGV, which is a very renowned business and law school in Brazil. And this study concluded that in reorganization proceedings in Brazilian RJs, dealing with debts above 500 million Brazilian reais, which is equivalent to 100 million US dollars, the recovery rate for banks is an average 11%. And this conclusion, it's also very low, and this came out as a big surprise to me. But it's very low because the way they calculated, they brought it, they based their study on the present value of the claim, and they applied an interest rate of CDI, which is our Brazilian interbank deposit rate, similar to LIBOR, and plus 10% a year, which was considered like an appropriate opportunity cost for this debt, right? And to finish and to wrap up, there was a recent article published in Migalhas, which is one of the largest digital media for lawyers in Brazil. And this article pointed out that according to National Justice Council, o Conselho Nacional de Justiça, only 5% of the enforcement proceedings filed in Brazil are concluded with some sort of recovery for creditors. The author that was very, very upset, clearly upset at the time he wrote the article, he stated that, and I'm quoting right now, there is a proliferation of the market for fraudulent RJs, which is the practice in which the debtor fraudulently and consciously spends long months and years diverting assets, shielding their gains in locations that are impossible to identify. I hope that until now. Until the shell of a liability of hundreds of millions in debt collapses, of which they will propose to pay only 10%. To be fair, I think there is an overstatement in this declaration. As I said, the author clearly was very upset with some case that probably he was dealing with. But even if there is an overstatement regarding the number of fraudulent RJs in the country, the fact is that, and I need to say that because probably most of us in this room, we haven't dealt with fraudulent cases in RJs specifically. So most of our cases and the big cases, we actually don't see the pierce of the corporate veil, but those cases that really happen, that incident, they became very famous and very, very, very well known about everyone. Let me just wrap up. Can I just wrap up?
Of course.
Just a little bit. What I really wanted to say is that those are very alarming numbers, and they show that creditors are overall very frustrated about the recovery rates in Brazil, right? And in response to that, and I will just pass on to you, but in response to that, we have been seeing an increasing number of trustees and courts willing to investigate and trace assets in Brazil. Paulo was going to comment on something. Sorry.
Yeah, I was just going to say that the fact that, hello everybody first, and thank you TMA for the event and Kobre for the invitation. That's a very nice event. But what I was just going to say is that the fact that there is no proceeding to pierce the corporate veil in a case, it doesn't mean that there isn't fraud. And there is also the fact that many cases in which there is a proceeding to pierce the corporate veil, there isn't fraud at all, just in an attempt to reach the assets of shareholders and officers and administrators. So I don't think we have an actual data on fraudulent cases. We have only data in which cases have been recognized as fraudulent, sometimes wrongly, and many other cases in which there was no recognition or no attempt at all to recognize fraudulent cases. We are all familiar with cases in both those instances, right? So I think there is, and also I appreciate all this, this collection of data. It really shows that as we are, of course, we are all aware in practice that liquidations and even reorganizations doesn't bring much to creditors here in Brazil, right? I would just like to ask you whether this 11% of recovery for banks, it includes chattel mortgages and fiduciary assignments, or just claims unsecured, secured, or everything?
No, just only those affected by RJ proceedings. And I'm talking about secured creditors, so class 2, and unsecured creditors, class 3. And Paulo just is touching in some basic and very deep problems that we do have in the Brazilian system. I don't think that we have time to explore that a little bit. But basically, what happens in Brazil is that most of companies here are not corporations. So they have an owner. And this really facilitates the environment for fraud, right? The other thing, and I think this is a real problem, Luciana touched a little bit on that, but there is a problem with the piercing of the corporate veil in Brazil and abuse of its use. And there's also a very interesting work that was published. I forgot the name of the author, but he questions the existence of the liability, limited liability company in Brazil due to the Bruno Salama, due to the abuse of piercing the corporate veil in Brazil. So I just want to wrap up very quickly saying that some of the very famous case that all of us in this room know that had to deal and had asset tracing and investigations, and they were very mediated cases, are MMX and OAS, both happen in RJ proceedings. Shaheen, Verglog, Banco Santos, and Felipe Vieira, I'm not sure if he's here, but he's a very experienced lawyer acting in asset tracing, and he helped me gathering some of the details involving all this case. He's worked in a lot of this case, and I'll be happy to share later with you. I don't think it's the right topic here. But just to wrap up and give the room to our colleagues here and understand how can they help us in the Brazilian chaos, in the middle of the Brazilian chaos right now. I just wanted to say that In Brazil, it is possible to commence a bankruptcy liquidation proceedings without necessarily proving an insolvency state in cases where there is evidence of fraud committed by the debt. And this could open the door to investigation and asset tracing proceedings offshore. And this is something that I think we should hear more.
Yeah.
Thank you.
Yeah, actually, when we have some frauds proofs and X that intends to deviate assets, it's possible to start a liquidation in Brazil, even it's not proved, it has proven the insolvency, actually insolvency of the company. So I would like to start with Pete, if he can explain this company to us of insolvency and insolvent liquidation proceedings in Cayman Island and the steps to do so.
Yeah, of course. Thank you, Marcos. Again, I'll start by extending my thanks to TMA for hosting this event. So just to pick up on where Marcos started, and that is the offshore jurisdictions do have, and I think to some extent continue to have, a reputation, thanks pretty much to Tom Cruise and Gene Hackman from about 1991. Cayman in particular, as that was the jurisdiction that was in that movie, continues to have that kind of reputation. I think the question is, well, is that really fair anymore? I think pretty much all of the offshore jurisdictions still have that sort of characteristic in the market, but it's also important to just alight upon the fact that every jurisdiction is different. So every offshore financial center has a different emphasis in the market. So using Cayman as an example, it probably continues to be the preeminent jurisdiction, offshore at least, for private equity funds, mutual funds, and hedge funds. So what history shows us is that the investors are the ones most likely to be the victims of fraud, and we can only name, the well-known cases: Madoff, Stanford, Petters, and the rest of them for the major Ponzi schemes. But what's important to remember about investors is that they're not necessarily treated as creditors, so they don't have the same access to the courts in the offshore jurisdictions as a creditor might do, for example, on an unpaid debt or financial obligation. So to deal with Marcos's question is, well, how then can they instigate a process in the offshore courts which involves the appointment of someone like David, and he can obviously talk to his experiences when I hand over a little bit later. How can investors instigate a process that allows the recovery of assets offshore and cross-border? Well, the answer is it's actually quite straightforward to do that, or at least it's not as difficult as you might think. And these processes don't rely on insolvency. What they require is someone that has been an investor, typically a passive investor, whether through a non-participating shareholder or a limited partner in an investment fund, to have held their position for 6 months. And if they find that there are certain red flags in the way that the fund is being conducted, so for example, the appearance of financial mismanagement, lack of information regarding the financial status of the fund or company, or the appearance of a conflict of interest, then they have access to the court on what's called the just and equitable basis. So they can file in court and ask the judge to appoint a liquidator without having to prove insolvency. So that's a good start. The issue is well, what does just and equitable mean? In what circumstances will the court appoint a liquidator? Well, needless to say, fraud and misconduct really stands alone. So if there is real fraud, where there's dishonesty involved, misappropriation of assets, then it really goes without saying. The judge is certainly in the Cayman Islands and the British Virgin Islands very, very ready and willing to appoint liquidators. The issue is, well, do you have to prove fraud? Because if you do, then typically you're talking about a trial, which can take up to 12 to 18 months to get on for a hearing, and obviously that's a long time, plenty of time for a fraudster to continue misappropriating assets, destroying evidence and documents and materials. So I just want to talk about how there has been a very, very definite shift in the offshore jurisdictions, and in particular the Cayman Islands, where judges have been willing to indicate at a very early stage of the proceedings that they think the manager that's in charge of the fund, or a general partner, should effectively give up and get out of the way so that the court officer can be appointed. And those cases really only involve having to show that there has been a loss of trust and confidence by the investors in the fund manager. So not having to prove fraud, or that alternatively there's a need for an investigation. There's been some very, very recent cases of that. One in particular involved a fund that was set up by the patriarch of the Coors brewery, as it happens, and the fund was to invest in developing countries and industries in Africa in particular. And the limited partners just felt that the general partner was not being upfront with the financial affairs of the fund. There was rumor that he had used some of the fund's money to build a pickleball court in Wyoming, and he was flying, certain people around in private jets. So there was a petition to appoint liquidators over the fund. And whilst it was contested in the early stage, the judge indicated pretty much from the outset that he could see no real reason why liquidators shouldn't be appointed, because 97% of the investors had basically lost their trust and confidence. So really what that shows, I think, is a willingness on the part of the courts of the Cayman Islands and elsewhere to intervene at an early stage in order to intercept fraudulent behavior from carrying on. Often that's not quick enough. So I think probably the next section is to deal with, well, what can you do if you need to move even quicker? And I think that probably is over to David.
Yeah, I'll pass the word to David here and tell if we have this liquidation proceeding or try, what are actually the tools that we have also there in order to try to, in any way, trace assets and recover assets when you're dealing with some fraud in the Cayman or offshore companies.
Good morning, everyone. And, thank you to Kobre and Kim and TMA for bringing me to the wonderful city of Sao Paulo for the first time. I'm very much enjoying it so far. The air is fine. I'm really not noticing any of the pollution. So I'll start off just by talking about the need to move quickly, because as Peter mentioned, sometimes when you have these fraud cases, you can get bogged down in a very long trial for 12 to 18 months, and all the while, an independent liquidator is not appointed to take control of the asset. So what can you do in the meantime? And there is a good solution, which is the appointment of what's known as a provisional liquidator. So at any time after you present a winding up petition on just and equitable grounds to appoint an independent office holder, you can also make an application to appoint a provisional liquidator on an interim basis. And the function and the role of a provisional liquidator is simply to preserve and protect the assets of the company until the court determines the winding up petition and whether an independent liquidator should be appointed. In terms of standing to make that application can be made by a creditor or a member or by the company itself. And the test really for getting that appointment, you have to show two things really. One is that there is a good prima facie case for making a winding up order, so that in other words, it's likely the court is going to make a winding up order in 12 or 18 months' time. And secondly, that in the meantime, there is a risk of dissipation or misuse of assets, or there is a risk of destruction of books and records, or some misconduct or sort of mismanagement by those in charge of the company in the meantime. You can apply to do this on an inter partes basis, where you give notice to the company, or you can also apply to do it without notice on an ex parte basis. Obviously, if you do it without notice to the company, you have certain obligations. The main one being that you must provide full and frank disclosure of all of your evidence to the court. The risk being that if you don't give that full and frank disclosure, when the matter comes on for hearing before the judge and the other side are present, if it's shown that you have deliberately or sometimes innocently missed something out of your evidence, that can be grounds for dismissing the provisional liquidation order. Another challenge with making provisional liquidation applications is that the applicant will need to provide what's known as a cross-undertaking in damages. And essentially what that is, you're indemnifying the company for any losses that are incurred as a result of the making of the provisional liquidation order, if it's later determined that the winding up order should not be made and the provisional liquidators should not have been appointed. So you're potentially opening yourself up to quite a significant contingent liability. And in some cases where the applicant is a company in liquidation, for instance, that doesn't really have any realizable assets, the court can sometimes require that cross-undertaking to be fortified by providing some security, so a payment into court or an insurance policy or something similar. In terms of the powers for provisional liquidators, as I said at the beginning, the main focus is on the safeguarding, preserving and protecting assets, stopping any dissipation. So usually the powers that are granted by the court are narrow and restricted to achieving those objectives. But one of the things that Peter and I have seen in recent times is the court being willing to grant much more expansive powers, so including the power to conduct quite wide-ranging investigations that are not strictly needed to preserve assets, but will be helpful for any future asset recovery efforts if you need to pursue litigation in other jurisdictions, for instance. And then we've also seen situations where the powers are extended to subsidiaries of the Cayman company that is under the control of the provisional liquidator. So you heard John from Kobre and Kim speak earlier about the companies in China often being structured through groups including offshore companies. So quite often a lot of our appointments will involve taking control of underlying subsidiaries, and we do that by virtue of the powers we're given in the orders. But it's unusual for extensive powers to be given for provisional liquidation. You normally get more wide-ranging ones as and when the winding up petition is determined.
Just one doubt here. Can the liquidator be appointed by the creditors? Because in Brazil, we have the trustee or the judicial administrator appointed by the court only. And we'll talk about it later. But can the creditors appoint someone to figure as a liquidator in Cayman and BVI?
So generally speaking, the appointment is made by the court, by court order that the liquidator is appointed. But when you make an application to put a company into liquidation, you always have to nominate a liquidator. So creditors will normally nominate a liquidator who they know has, the relevant experience, the right resources, the industry expertise in whatever the case involves. So the petitioner will nominate a liquidator, and then what happens when you have the court hearing, if there's a dispute about whether that appointee is an appropriate choice, for example, there might be allegations there's a conflict of interest because the liquidator's firm has previously worked for the group somewhere else in the world. Other creditors can propose different nominees. So you have a situation where the court is faced with deciding whether to appoint me or someone else from PricewaterhouseCoopers. And the way the court normally resolves those sort of differences of opinion is quite simple, really. It generally goes with the majority of creditors. And when I say the majority of creditors, I mean majority of third-party unrelated creditors. The court places quite a lot more weight on their views and opinions than on, say, an investment manager that has a vested interest in appointing a particular firm because they think maybe the investigation won't be as thorough if it's done by that firm as opposed to another firm. So it's primarily the creditors that decide, but the court makes the appointment.
Okay. Oh, pass the word now to Paulo again and to speak a little bit. No, okay, of course.
Quick comment. I think that this issue is really interesting and appealing to us here in Brazil right now because there is the Bill of Law number 3 from 2024 that is discussing or is proposing a major reform to bankruptcy liquidations in Brazil. And basically, the main issue that is being discussed, and I mean heavily discussed between us, all players, all Brazilian players, is whether the trustee or the equivalent, person equivalent to the trustee, with the trustee powers a little bit broader than that, should be appointed by the creditors themselves or continue to be appointed by the judge, which is the rule right now. So I think this is very interesting to understand that, and kind of I like that solution because it's halfway, right? So creditors have a say, but basically there's the recognition that the liquidator or the trustee would represent the interest of creditors and not is not a special figure or someone that has the trust of the judge and just the court's trust. So it's very interesting.
Yes, I think it's not uncommon in lots of jurisdictions for trustees to be appointed on almost a rota basis, where it sort of moves from one experienced professional to the next, with the creditors having no say. But the fundamental principle in the offshore jurisdictions is whoever has the economic interest in the outcome of the liquidation, it's they who should decide how the liquidation is conducted and by whom. And it's a pretty good principle, I think.
So I pass the word to Paulo to speak a little bit about the tools that we have in Brazil for tracing and recovery assets, especially in the liquidation proceedings.
Okay, thank you. I'd like to thank GMA and Kobre again. That's my turn now to speak, right? And just a little word about the appointment of the new Bill of Law, right? They inserted a provision in which creditors may decide in a creditors meeting, right? So it's a different solution to replace the judicial administrator by a fiduciary manager. That's the name they adopted. Because judicial manager is already taken, I think. So a fiduciary manager to take over the role of the judicial administrator, and that can bring many discussions. The bill is very controversial, as you know, including whether if the same person should be responsible for collecting the assets and searching for the assets and assessing the list of claims, verifying the claims, should be the same person. Should the creditor appoint both a person for these two roles? So that could bring lots of discussions in this sense as well, right? Including because if the guy who's going to verify the claims is also the guy who's going to be voted by the creditors meeting, right, and the votes come from a percentage of creditors that might raise a conflict of interest, right, in the verification process, including, right. So that could be discussions. Is not. I'm running away from the theme, right? Going back to the theme now, Brazil has some tools for tracing and recovery of assets, and the law in 2020 it modified the bankruptcy law in many aspects, including on these tools to pierce the corporate veil within a bankruptcy liquidation proceeding. Before the law, it was very common for courts to extend the facts of a bankruptcy proceeding to third parties. And it was very common, and sometimes we've seen officers and shareholders of a company waking up with their bank accounts frozen out of nothing because there was a decision in a bankruptcy proceeding determining the freezing of those assets. So they were very afraid of this happening without any reason, right? The court just decided that based on the report of judicial administrator stating that there was fraud, or sometimes there was, sometimes there wasn't, but the guy didn't have time or the opportunity to submit a defense. So this new law stated that basically there should be no extension of bankruptcy facts to shareholders and officers, and that if it was possible to pierce the corporate veil of the bankrupt company, but that would require a proceeding according to the Code of Civil Procedure to assess the fraud and commingling of assets and to reach out the assets of these third parties. And that is a tool available, right? It's being there are discussions on whether this should be modified, and there is a modification included in the bill of law. But about the effectiveness of that, when the company is bankrupt and there is such a proceeding discussing on whether the third parties should be responsible for the debt of the company. In many cases, creditors are in their enforcement actions that they may file against the debtor company. When the bankruptcy proceedings commence, the enforcement action against the bankrupt company is stayed, but not against third parties. Sometimes it's common for those creditors to go after those third parties during the course of the bankruptcy proceeding. So when such a proceeding to pierce the corporate veil within a bankruptcy proceeding is granted by the court, the assets of the third parties are already taken. There are banks who have personal guarantees and go after those assets of third parties, of officers and shareholders. There are labor creditors who go after those assets, the tax authority. And in many cases, we've seen that those assets are already frozen in individual lawsuits, or the shareholders and officers have already taken measures to protect their assets and put them in the name of third parties or abroad or someplace else, which are a little bit more difficult to find. That's pretty common, right?
Yeah, and in RJ proceedings, it's in liquidation and bankruptcy, we see it more frequently, the pierce of the corporate veil, and before that, the extension of the effects of the bankruptcy. But it's not common to have in RJ proceedings in Brazil the same measures, right?
Yeah, it's not common. It's not provided by the law. The law doesn't provide for piercing of corporate veil within a judicial reorganization proceeding. We have seen attempts of that. Just a handful of attempts of that, but how that could be effective is still a mystery to me, because the plan of reorganization, it's an agreement approved by the majority of creditors and by the debtor, and the assets, even if you're successful in in an attempt to pierce corporate veil within a bank reorganization proceeding, it doesn't mean that those assets would have the destination that the creditors would want, because the plan of organization may have some, the destination of the assets of the company within a reorganization proceeding is not necessarily to pay the creditors. It may be used for the continuation of the activities of the debtor. You don't necessarily have to sell the assets within a reorganization proceeding to pay the creditors. So if you include the assets of the shareholder and administrators within a judicial reorganization proceeding, it doesn't mean that they will be sold for the satisfaction of the creditors. And even if you don't have a person of corporate veil, the shareholders and officers can reach an agreement with the creditors in the sense that they can voluntarily submit their personal assets for the benefit of the company within reorganization proceedings. So we have two things here. The law doesn't provide for this kind of measure, and because in a certain sense it's kind of incompatible with what the reorganization proceeding is and its purpose and its mechanics. And it's a difficult task to make it compatible, right?
Okay, you want just to add something?
Yes, thank you, Marcos. I just wanted to add that I'm agreeing with Paulo, it is very controversial if the pierce of the corporate veil plays out and it's feasible in restructuring proceedings. But, and also if the judicial administrator or the trustee has legal standing to represent these ancillary proceedings within the RJ proceedings, right? So there is a gray area here, but despite that, I think that we have been seeing a lot of cases in which the pierce of the corporate veil is commenced in Brazilian RJ proceedings under secrecy and ex parte. So the debtor simply doesn't know what is going on until one day there is a decision, the guy is taken out of management, right? And then the trustee is put in place by the court with a very big hand, right? The court really plays out a force role in this appointment. And the debtor, a lot of times, or it's been very common, he doesn't really have the means to defend himself in satisfaction. But also I think that this has been happening in the early stage of the proceedings. So this has been very criticized by most of the players in the field, but many judges have applied the disregard of the entity, legal entity in RJs, using that tactic in the beginning of the proceedings.
Yeah, because if it's a tool that the court makes it available for creditors, creditors may use it as a tactic to get leverage, right? And if an individual creditor can do that, it gives a lot of bargaining power to that specific creditor, right? It's, as I said, I think it's incompatible with the reorganization proceeding, although some courts are allowing this, right?
Yeah, we should have a panel, teammate, take the notes just on this matter. I'll now ask David, and again, what about the liquidation tools for tracing assets offshore? So we have commented the pierce of the corporate view in Brazilian, but how does it work in BVI and Cayman and so on?
I wish we had the power to pierce the corporate veil more easily offshore. It's actually exceptionally difficult to do so and really requires some quite specific facts. But generally speaking, a liquidator will step into the shoes of the directors of a company when appointed. So most parties should recognize the liquidator's right to obtain information. So, for example, from the company's bank, legal advisors, other service providers. But just in case those parties are not cooperative, the legislation, the statute contains specific powers whereby a liquidator can apply to court to require certain relevant parties to either provide information or to deliver books and records to the liquidator, or that those parties attend an examination under oath to provide information about the company's affairs. So that can be particularly helpful when you have an uncooperative board of directors or former board of directors. In terms of other discovery actions, we often will employ other options under the common law. So that the three sort of main sort of things we use. The first one is called a Norwich Pharmacal Order, and that's essentially a disclosure application that you make against a party who has been innocently caught up in wrongdoing, and it allows you to gather information about that wrongdoing for the purposes of subsequently pursuing a claim against the wrongdoers. So Peter and I actually have a case at the moment which involves a misappropriation of sort of $175 million worth of assets, and we think we've tracked down where they've gone to, but we've made one of these applications just to obtain information from a third party that will assist us in pleading our claim. There are two other similar applications that can be made. One is called a banker's trust order, and as the name implies, that's where you're trying to get information from a bank that holds accounts from parties that have been involved in the fraud or have received the proceeds of the fraud, and the relief is designed to help you sort of identify and track down the location of those assets. And then thirdly, you have what's known as an Anton Pillar order. Sorry for all these silly names, they come from English cases. But that is effectively a search and seizure order that allows you to enter premises for the purposes of seizing data. And it's obviously quite topical in a crypto context where you can go in and seize sort of cold wallets and other data that will allow you to trace those assets. So from a discovery perspective, that's what you can do. We also have specific powers to challenge transactions. And most of these powers will be quite similar, I think, to the powers that you will have in Brazil, or certainly US trustees have in Chapter 7 and Chapter 11 proceedings. So the first one is preference payments, so where a creditor has received assets or payments or has been given security within 6 months prior to the liquidation. And the reason they've been given the payment or security is to put that creditor in a better position than others. A liquidator can apply to court for an order to set aside that transaction as being void. Similarly, if you have transactions where assets have been disposed of or transferred in the 6 years prior to the liquidation, they've been transferred for less than their value, and really with the intention to defraud creditors, a liquidator can apply to void that transaction. There are also other applications that can be made. If you can prove that a business has been carried on for a fraudulent purpose, you can apply that anyone who has participated in carrying on that business knowingly, you can apply that they make a personal contribution to the assets. So I guess it's sort of piercing the veil in a more low-key way. And then finally, there's an interesting or helpful provision that we use quite a lot, which is under the company's law. Once a petition, a winding up petition, is presented against a company, any transactions that take place after that moment are potentially voidable if the company has, if a winding up order is subsequently made. So what it means is that if a winding up order is made and assets have transferred between the filing of the petition and the making of the order in, say, a year's time, unless the court specifically approves those transactions, they are void, and a liquidator can recover the assets that have been transferred. So those are the main ones. Have I missed anything, Peter?
We have also some clawback provisions in our bankruptcy law, even by a court decision or by some revocatória, what they call the revocation lawsuit. I'd like to just pass the word to Pete now to wrap up here. We have more topics, but I think we're running out of time. But again, if you can explain to us about the recoveries, if they are similar in the Cayman and the US, what difference, and how can you explain this to us?
Yeah, sure. Thank you. So I'll come back to my Cayman Islands Law Roadshow, if I can, for a second. So David's absolutely right to point out that the ways or the claims available to recover assets are probably quite similar across jurisdictions, and they're probably quite similar as between the Cayman Islands and the United States. So you'll probably all be familiar with, I would say, the standard playbook strategy of taking an offshore liquidation and having it recognized under Chapter 15 of the United States Bankruptcy Code in the United States. What often, or what can come up then, is when a liquidator obtains that recognition, what are the best series of claims that can be pursued, say, for example, in the United States? Does it automatically follow that you should just look to pursue United States causes of actions, or is there an argument that actually using Cayman Islands law might produce a better result? And I just want to take a few moments to deal with the answer, well, maybe it is better to use Cayman Islands law. So there is one case at the moment proceeding in the Southern District of New York, which is called the IIG Global Fund case, which has been recognized in Chapter 15 and is currently in an adversary proceeding with several third parties. So it's effectively claims to recover assets from third parties that have received them from effectively a fraudulent Ponzi scheme. Now, this Cayman Islands fund was set up to invest in trade finance loans made by SME commodities exporters in Latin America, in particular Brazil, Peru, Uruguay, and Argentina. The managers effectively started incurring substantial losses probably in the early 2010 time period, and they, in order to conceal those losses, started inventing new loans or extending loans that had already gone into substantial default. By 2017, they'd managed to carry on perpetrating their Ponzi scheme by paying out investors from the proceeds of new investments. But it came to a stage where they had to take further action. So what they did was they securitized the portfolio by a CLO, and notes were issued to certain well-known institutional investors. As time went on, even those investors started to realize that things weren't going quite right. And by the end of 2019, these notes were also in default. So the question arose as well, why aren't we getting paid out? Now, as it happens, the note holders started to receive information that so many of these loans had gone into default already, but they were still given a full par value on the financial statements. So even knowing that they were invested in a bad financial product, they then decided to sell the interest to some unsuspecting Korean investors for $220 million. So the note holders were perfectly happy. They were sold out, but they had a good degree of knowledge as to what had gone on with the default position in the portfolio and the CLO. So proceedings were launched by the liquidators against those third-party recipients to try and recover effectively the net winnings that they got out of the Ponzi scheme. And the question that has come up in the adversary proceeding is whether it's better to pursue a claim under New York law for aiding and abetting a fraudulent conveyance, or whether it's in fact better to use Cayman Islands law, which, as David's mentioned a moment ago, is based on fraudulent trading. So where the business of the company or the fund is carried on with an intent to defraud creditors, and it's done so knowingly by third parties, then those third parties can be made liable as well. So it's a very good way of reaching third-party recipients of substantial funds. And there's a real argument, because it's at the motion to dismiss stage, there is a real argument that Cayman Islands law is better, because all that's needed to prevail on a fraudulent trading claim under Cayman Islands law is the business has been carried on in a way that defrauds creditors, and there is a certain degree of knowledge about that by the third party. Under New York law, to successfully pursue a claim for aiding and abetting a fraudulent conveyance, the third party has to provide substantial participation in the fraud. So there's more that needs to be shown in a New York claim. So it's a good illustration of actually how Cayman Islands and offshore law can be used even onshore when recognition has taken place.
Thank you, Pete. Well, I think we're arriving in 10 minutes. Anyone from the others has any questions about the panel? No, if don't, just we're going to wrap up here with David, if he can just talk about a little bit about costs and timelines for this Offshore's appointment. I think it's one of the points that we didn't reach out, but if you can wrap up with this appointment, it will be good for us.
Okay, well, going back to Fabio's point at the beginning, I think we all want more lawyers' fees and accountants' fees. It's a very good topic to finish on. It can be a relatively inexpensive process to commence a proceeding. We didn't speak about this at the beginning, but if you are trying to start a liquidation in Cayman as a result of fraud and you're a creditor, it can be quite a quick summary process if there isn't a substantial dispute about the debt. So in those cases, it can be quite cost effective and quick to get into court and get your liquidation order and then commence your investigation. But obviously, if you have a more factually difficult case and you're applying to wind up the company on a just and equitable ground, it can become protracted and it can get expensive. And the difficulty is that, often in these cases, well, almost invariably in these cases, the fraudsters are not considerate enough to leave a fighting fund behind to pursue the investigation. So it often becomes a case of needing to look for third-party litigation funding if the defrauded investors or creditors are not willing to provide it themselves. So, usually what you will need to do is you will need to at least fund your Cayman or your BVI counsel to present the petition. For an unopposed petition, that could be very reasonable. I think you're probably talking, a few tens of thousands. But obviously, if you get into a more protracted dispute, you could be looking at several 100,000. The other thing to consider, and I think it's the same here in Brazil, that we have the loser pays system of litigation. So if you do get involved in quite a contentious dispute and a long-running winding up proceeding, you can end up being responsible for the other side's costs, which is sometimes a deterrent for people pursuing a liquidation in cases of fraud.
Okay, thank you, everybody.
Hello, everyone. We're going to proceed with our final panel. Brazil-focused asset recovery, U.S. Chapter 11 and 15, bankruptcy tools and beyond. The moderator here on stage, Luis Fabiano Sariagioto, partner at Journey Capital and chairman at TMA Brazil. The speakers, Dan Saval, partner at Kobre & Kin, Dora Laporta Rothschilling, analyst at Prisma Capital, Liv Machado, partner at Toyo Checker Advogados, Marcelo Lamego Carpenter, partner at Sérgio Bermudes Advogados. Thank you.
Hello. Good good morning, everyone. Great honor to be here moderating this panel. I'd like to, on behalf of TMA, thanks Kobre and Kim, Dan, and Victor for helping us putting this together. Pretty exciting and insightful event. On this third and last panel, we're gonna talk about Brazil-focused asset recovery and talk a bit about Chapter 11 and Chapter 15 bankruptcy tools. I have the privilege of having with me Dora Laporta, Liv Machado, Marcelo Carpenter, and Dan Saval. Instead of me reading the bios, maybe more friendly is if each of you could please just quickly introduce yourselves, and then we start the panel. Dan?
Well, first of all, thank you, TMA, for hosting. Thank you all for being here. I'm excited to be here. I love coming to Sao Paulo, and I love coming to Sao Paulo to talk about restructuring and insolvency, because there's a lot of exciting activity happening here that is being transported essentially to the US and other jurisdictions. Just brief blurb about myself. I am a partner with Kobre and Kim in the New York office. I do a lot of work in contentious, complex Chapter 11 and Chapter 15 cases. Most of my work touches on several jurisdictions in which I am putting together cross-border insolvency plans using cross-border insolvency tools to help assist asset recovery and judgment enforcement initiatives, as well as working with distressed debt investors who will acquire position in these restructurings or seek to use insolvency as a tool in order to monetize their claims or judgments they may have acquired.
Thank you, Dan. Liv?
Thank you, Fabiano. Good morning, everyone. Thank you so much, TMA and Kobre and Kim, for the invitation. It's a great pleasure to be here with the great colleagues, brilliant colleagues here to join this panel. I'm Liv Machado. I'm a partner at Tyers-Smith in association with Meyer Brown. I'm based here in São Paulo, and we typically represent creditors in judicial organization, bankruptcy cases in general, and then we also work a lot in cross-border cases. I would say it's our target in the firm here. So good to be with all of you, and thank you so much.
Thank you.
Good morning, everyone. My name is Marcelo Carpenter. I'm a partner at Sergio Bermudez. And thank you, Fabiano, Daniel, Kobre King, TMA, my colleagues. It's very good to be here to share with you some thoughts, maybe some doubts, more than thoughts about insolvency. But I've been working with insolvency, assisting creditors and debtors for many years in Bermudez in litigation. So that's my life in the brief.
Hi, thank you, Fabiano and Kobre and Kim TMA for hosting this event. My name is Dora Laporta. I'm an investment analyst at Prisma Capital, but I'm also a lawyer with a litigation background. And when I used to practice and here at Prisma, we usually look at cross-border insolvencies and discovery proceedings. So I'm really excited to be here and talk to you guys.
Thank you. Thank you all. Let's get started. We thought of starting the discussion, the panel, with a brief overview on Chapter 11, Chapter 15 filings for Brazilian debtors, and maybe then you can start by telling us about what would be reasons for a Brazilian debtor to file Chapter 11 or Chapter 15 in the U.S.
Happy to kick it off with that topic because I think, as most of you know, there's been a bevy of Brazilian restructurings or insolvencies of Brazilian or LATAM debtors that had touched on the U.S. either through Chapter 11 or Chapter 15. Thought it'd be interesting to talk about Chapter 15 first. We are approaching the 20-year mark since Chapter 15 has been enacted under the U.S. Bankruptcy law. As many of you know, Chapter 15 is based on the UNCITRAL model law on cross-border insolvency. And so the representative of an insolvency proceeding in Brazil or elsewhere is able to come to the U.S. courts. Typically, but not always, they will come to the New York Bankruptcy Court or the Miami Bankruptcy Court. We've seen some cases recently filed in Delaware, and I think that many of the U.S. bankruptcy districts are essentially marketing themselves as being hospitable to trustees, whether from Brazil or other countries. The way I view Chapter 15 is in two ways. You have both offensive uses of Chapter 15, which are typically, but not always, run by bankruptcy trustees acting for the benefit of creditors or acting through the creditors themselves. And then you have what I'll call the defensive uses of Chapter 15, which are typically used by the debtor companies themselves. And the reason why I refer to the defensive use of Chapter 15 is that when a proceeding is recognized under Chapter 15, under the model law standards, the automatic stay of the U.S. Bankruptcy Code immediately comes into effect. And for those of you who are familiar with the automatic stay, you'll know it's quite powerful, and that the sanctions for disobeying the automatic stay can be severe. If you're subject to U.S. jurisdiction, you can be subject to contempt penalties. For most commercial actors, they will have a presence in New York or elsewhere in the U.S. that makes them vulnerable. And what makes it particularly valuable and important to effectuate Brazil-based or LATAM restructurings is that many of the bonds that have been issued by the company are USD bonds that provide for jurisdiction in the U.S. courts, usually the New York courts, to bring litigation. And so with Chapter 15, you're able to almost immediately shut down bondholders from bringing that litigation. And I think that many of you have been consumers of Chapter 15 for that very purpose. The other aspect of Chapter 15, or category, which is, in my mind, more interesting and more creative and, frankly, more cross-border, is the offensive use of Chapter 15, which are the types of scenarios we often get involved with, where there's an opportunity to come to the U.S. to try and collect assets, recover assets, or obtain information that could be critical to formulating litigation to be brought either in the U.S. or elsewhere. One of the interesting aspects of Chapter 15 is that while the scope of it is limited to assets within the territorial jurisdiction of the U.S., if you're using it, for example, to obtain discovery or information, there's no limit on how that discovery or information can be used. So when you're thinking about using a Chapter 15, as we often do, as almost a piece on a chessboard or as a tool in the toolkit, and you have a LATAM restructuring with, let's say, fraud or dissipation of assets, and U.S. banks are involved, the Chapter 15 could serve the purpose of getting information from those banks to then launch litigation wherever the assets can ultimately be traced to.
whether it's Europe, whether it's offshore, where a lot of the principals of shareholders of companies in Brazil and elsewhere, other high net worth individuals often set up their asset protection structures. So we've seen a lot of interesting examples of how Chapter 15 can be used in that way. Perhaps I'll just give an example from my own experience. It doesn't touch on LATAM, but I think may provide a blueprint for those of you who are thinking about how you can use Chapter 15 in this way. I was involved in a case involving a crypto trading platform based in the UK called Duga that was hacked, and Bitcoin was stolen and transferred to accounts and exchanges all over the world. Through what's called a blockchain tracing exercise, which is basically using special software that allows you to search the blockchain, which is publicly accessible, we were able to identify that some of the stolen Bitcoin found its way to exchanges based in San Francisco. What we decided to do after learning that was file a Chapter 15 case in San Francisco in support of a UK liquidation of this platform. And once we obtained Chapter 15 recognition, we were able to use the discovery powers of Chapter 15 to get information about the owners of the accounts that had stolen the Bitcoin. We learned that they were Chinese nationals, and there was a separate work stream involving pressure tactics in China. And I know John talked about some of those on his panel. But for purposes of using the Chapter 15, what we're able to do is get what's called a turnover order using what's called entrustment relief under the model law in Chapter 15 to compel the exchanges in San Francisco to turn over the stolen Bitcoin to the liquidators, ultimately for repatriation to England, where the liquidation was pending.
That's quite interesting, and I don't think that strategy has been used by Brazilian, at least not for my knowledge, but having the opportunity to use the ample scope of discovery proceedings in the U.S. for identifying offshore assets or activities it's pretty powerful. Thanks, Dan. Dora, one of the aspects that we've discussed is under Chapter 11 and 15, but has a big differentiator for debtors, is the possibility of deep financing, right? And how developed it is in the U.S. Can you comment a bit about that, please?
Okay, is it working? Yeah. So whenever we look at the numbers of companies in distress, it's not hard to reach the conclusion that's really difficult to have an actual recovery without injection of new money. But of course, the haircuts and the extensions and new maturity dates, they sure helps, but it's really hard to seek an actual recovery without the injection of new money. And I think this situation is intensified when it comes to Brazilian debtors. I don't know what's the psychology behind that. Maybe the fact that 90% of the companies are family-owned, and there's the pride of not filing for reorganization and bankruptcy proceedings sooner than later. So we have this situation in which we need new money and we need fast money. And I think this is where the major difference between Brazilian and American proceedings, it's where it lies, because in the United States, we're used to seeing huge DIP loans to be granted and really fast. When we were discussing prior to this panel, Dan even mentioned the case that he said it was granted within a 24-hour span. So within a day, I don't know, maybe you can comment on that. So that's really interesting. I think that from the capital allocator perspective, the recent, not so recent, but the 2020 changes that provides that. The collateral given to the financer in a DIP loan situation that's been validated by the court and provided for in the plan should not lose its effect, even if the plan is nullified and there are other just discussions related to that. So I think the American perspective is more friendly to capital allocators and even more friendly to actual reorganization. But the recent cases in Brazil, I think we're moving and walking towards a situation in which there's more, I think courts will be a more hospitable environment for actual recoveries and for the injection of new monies. Because I think in the beginning we had the DIP loans were this foreign thing that people were not used to. Right now, I think it's been a few years that we're very familiarized with that. But I think that we're walking towards a scenario in which there will be even more security to those who decide to lend money to companies in distress and just really help the company other than having a liquidation, even if it's not called that, because we see reorganizations take a lot of long years, and then after 10 years, there are no assets, there's no activity, and then it's just should have been a bankruptcy proceeding, a liquidation proceeding from the beginning.
Absolutely. Dan, you want to comment on that? Or, it's that there's a major difference, right, in what we call deep financing here in Brazil than how it's used in the U.S. U.S. deep financing is usually in the beginning of the process to finance the process, among other things. And here, Brazil, we call deep financing, but it's much more similar to the exit financing in the U.S., which is the take back debt, right? The debt that refinances the deep.
Yeah, I'd make two quick points. Number one, you have to appreciate the difference between the law and the books and how it works in practice. And really the way DIP financing, what makes it unique in the U.S. is that there is a restructuring culture that's been developed over years and years, I'd say decades, where the parties, the judges, the lawyers, the financiers, all understand sort of how it works, are comfortable with the system. And so my perspective is that, we will see more robust DIP financings, in Brazil proceedings as that aspect of the restructuring culture develops. The other point I would make, which I think is a reason why investors may prefer the U.S., even with the availability of DIP financing in Brazil, is there's this somewhat recent phenomenon of creditors using DIP financing, not only to fund the company, but to get case control mechanisms in place, where included within the covenants are provisions such as requiring that the plan be acceptable to the DIP lender, for making it very difficult for dissenting creditors to have the ability or the funding to do investigations or bring claims. So I think that's an essential aspect of the game that gets played by these sophisticated investors, and that it'll be interesting to see if Brazil, if those attributes of DIP financing make their way into the way in which these proceedings play out.
Yeah. One other area or alternative for Chapter 15 that is pretty recent, and I think it's been sort of tested here in Brazil is the filing and use of Chapter 15 in a prejudicial reorganization case, right? In a mediation, right? I think there's a case ongoing right now with this element. Do you want to comment about this possibility, and then can complement from his experience?
Okay, sure. So the Chapter 15 is usually used for judicial reorganization proceedings or similar figures in other jurisdictions to have the protection in the United States. But when the 2020 law came into place, we had this new kind of proceeding, which is a pre-proceeding, but it's considered a proceeding for the means of the Chapter 15. So we have that 60-day period for mediation, and that has recently been considered a foreign proceeding eligible for having the Chapter 15 protection while the negotiations were in place. So I find that it's a new use of the Chapter 15, but that served the purpose of the institution. I mean, it's to protect assets while the negotiations are in place, whether during a judicial reorganization or a proceeding phase in which the claims are stayed.
Any comment?
I think that case, I believe it's Intercement, is remarkable. And it's really a blueprint for how I think Chapter 15 can be used quite creatively and expansively. And it's also a lesson that while the fundamental principles of Chapter 15 and model law proceedings are to grant comity to the foreign main proceeding and give effects to the foreign main proceedings, you can get relief above and beyond what you get in the main proceeding in the US or elsewhere, because with this Chapter 15 Intercement, even though there's just a mediation process going on in Brazil, you get the automatic stay. There's the ability to take and apply for discovery rights. Potentially other claims could be brought. So I could see in similar situations an opportunistic debtor that's looking to dilute the ability of creditors to litigate elsewhere, that a Chapter 15 strategy modeled on Intercement could be quite powerful.
Yeah, and on the other hand, the difficulty about a process in the US, and this has become an increasing issue that's always brought about is the cost, right? It can be an efficient process, but the cost may be prohibitive with costs of creditors committee and so on and so forth. Anything to be done about it then? In order to make it more attractive for foreign debtors?
I guess two things. Number one, I think from the perspective of many U.S. restructuring professionals, if you file for Chapter 11 without a pre-negotiated or pre-packaged plan, it's often considered not to be a successful case, and that the only way to make sure it doesn't turn into litigation chaos is to have things buttoned up with the major creditors, have an agreement in place, and do things to make it more difficult for dissenting creditors to exercise their rights. The second point I would make is, and it's actually a challenge to the question, is how can foreign jurisdictions make themselves more attractive to do the things you can do in Chapter 11? But in another jurisdiction, and we're seeing, in Brazil and elsewhere, essentially the exportation of some of the key aspects of Chapter 11 that can make the proceedings less costly. Going to what was discussed in the prior panel, there's some precedent for using the Cayman Islands, which has a developing restructuring regime to carry out the restructuring. So maybe that's an option for folks in Brazil to consider. And with the proliferation of model law proceedings around the world, you could see a scenario where, investors do get comfortable with a judicial restructuring here and getting access to model law proceedings elsewhere. So.
Yeah, and Liv, maybe you can comment a bit, or Dora, on the recently enacted model law, and and the drivers for a foreign debtor to seek recognition in Brazil under model law, right?
Of course. Brazil adopted the UNCITRAL model law, but with a couple, let's say, tweaks to adapt the UNCITRAL model law to the Brazilian bankruptcy law. So I think one good example and one point that would be a game changer for a debtor to decide whether or not to seek recognition in Brazil is the point I think that Julia and Fábio briefly commented on the Mercon case, but one important point is our law, our cross-border, the part that provides for cross-border in the bankruptcy law, says that there are certain claims that are not subject to the judicial organization, and they are not also subject to a recognition proceeding, such as the famous ACCs, adiantamento de contrato de câmbio, the exchange agreements, and other claims such as claims holding fiduciary liens. So those creditors, they have the ability to enforce their claims outside of the environment of a judicial organization. And we have this specific provision in our law saying that also in recognition proceedings, those creditors should not be affected. And that's interesting because, as Dan mentioned earlier, the stay period in the Chapter 11 is universal, right? So as he mentioned before, the judge, the court can even establish a penalty for the creditor that violates the stay. So we have, on this point, a clear conflict between what the legislation in the US says, right, about the stay that is universal, and at the same time we have a Brazilian legislation stating that certain creditors are not affected by the recognition proceeding. And jumping to the example of the Mercon case, that was exactly the case. Actually, this was the first Chapter 11 that we had a recognition in Brazil, which is quite exciting and interesting, but at the same time, Mercon had a couple ACCs agreement with local banks here in Brazil. And at first, they just informed the court that those were loans without providing the specifics that in this case, it was an exchange agreement. The court simply granted a decision recognizing the Chapter 11 and granting the stay and now the facts. In this case, my firm represented two of those local creditors holding ACCs, and we filed a motion for clarification, clarifying this point to the court, saying that in Brazil, those contracts should not be subject to the recognition proceeding. And the court granted our motion and recognized that this provision is in place, should be respected regardless of the provisions of the Chapter 11 of the Bankruptcy Code. But in practice, we have a clear conflict because if there is eventually a creditor that has operations in the US, the US judge could eventually set a penalty to this creditor. So now we have a clear conflict of the law, especially in this case.
Is there an appeal pending on that, or?
Yes, there is an appeal. Of course, the debtor filed an appeal against this decision. They requested an injunction, but it was rejected, and now the appeal is pending, the final ruling of the appeal. So let's see how it goes.
Okay. Any precedent you see there in the Chapter 11 proceeding for that? It's pretty interesting a conflict, right? And one of the weaknesses, I would say, of our judicial recovery that has all of these exceptions. So not everybody is brought together under the tent, right? Yeah. So you have the extra concursais, which can create very important challenges for the local proceeding, right? Something that you don't have.
Yeah, I mean, there. Notwithstanding the broad reach of the U.S. automatic stay, I think going back to John's panel, creditors based in China, where the courts aren't going to recognize the automatic stay, are practically free to enforce against assets of a debtor that files for bankruptcy there. And there was a case I was involved in that I worked on with John, which involved a high-profile, high-net-worth individual who filed Chapter 11 in the U.S., but only about half of his assets could actually be administered in the Chapter 11 because of that phenomenon. So that, I think only increases the need to think about where you can file model law proceedings because the U.S., is not always the end-all, be-all.
Great, pretty interesting. Marcelo, talk a bit about the tools, right, in bankruptcy proceedings. Like to hear your views on view person orders and fraudulent conveyances in the U.S. And in the Brazil. Talk about the standards here and the mechanics and the differences over there.
It's interesting, Fabiano, you mentioned that. Daniel just mentioned the broad scope of the discover in the chapter 15, and we just ended the case, closed the case in which all the assets were in Brazil, but all of them controlled by foreign companies, by American companies, by European companies. And then we need to file for the view on the person of the corporate entity and fraud conveys actions in Brazil. But in order to do that, we need to file a Chapter 15, the trustee in the US, to have access to the actual information about the entities that were controlling the assets in Brazil. So what is interesting is that sometimes we think that usually the assets are hidden abroad, and not necessarily. Sometimes they're hidden here, but using very complex corporate structures that hidden the real owner of the company, which in our case was the debtor, through many companies, sisters, sons, nephews, and etc. And then we found in the U.S. and in the Virgin Islands to have access to that. It was really important to do that because we had access. And then we brought this information to Brazil. And it was just one light information. These data used to travel a lot, ask permission to travel for religion purpose. And he always filed kind of a letter of recommendation from a religious persons abroad. And then what we did in the Chapter 15, we asked this religion person to testify, say, you know this guy because you've been sending letters asking him to come to the United States to join your religious events. He said, I never heard him, never saw him before. And at the end of the day, we found out that there is, the religious guy has another religious guy in Brazil who he was a friend of him and said, could you please send a letter for someone? He said, okay, I'll do that. He had no idea what he was doing. And believe it or not, this was very important tool, pressure tool, to make the guy settle. Because now we're not only putting pressure on him on assets, but on the religion community. He was being exposed in his religion community, but, just side aspects of Chapter 15 and using the Chapter 15. But that all was only possible because of the broad scope of the Chapter 15. And as you mentioned, the release, the corporate veil, and the standards, we found out in this case that asking for for reaching third parties through fraudulent conveyance actions would be easier in Brazil in that specific case than in the US and cheaper in Brazil. So what we did, we got orders attaching third-party assets because of fraud. But then in order to do that, we use the Chapter 15 to have access and even to frozen the assets to avoid the new transfer of the assets abroad. So it was a mix of strategies used, but the bottom line, what I do want to say is that I might be wrong, but from my perspective, sometimes Brazilian courts might be more open to access requests for disregard of legal entities and fraudulent conveyance, which is not necessarily good. I mean, sometimes they are too open and too broad, so give some uncertainty. Yes. So sometimes we have a too broad understanding of the boundaries of this entity. But in fact, my sense is that it might be easier sometimes to get these orders, and cheaper certainly in Brazil than abroad. I don't know, Dan, what's your view on that?
Yeah, that's a really, really great point on mapping out a strategy in these, situations often involving fraud, where you're looking to get the most powerful tools in each jurisdiction. So in Brazil, probably the veil-piercing remedies are more potent than they are in the US or elsewhere. So if you can get those veil-piercing orders, then you can then come to the US or elsewhere, file a Chapter 15, and have the alter egos or the individuals whose veils had been pierced treated as debtors. For purposes of the Chapter 15, I've been involved in 2 of those cases in Miami, where the US bankruptcy courts were willing to treat the alter egos as debtors, allowed discovery against them, and if they hold assets in the US, those assets are subject to turnover to the trustee. And then, if those alleged alter egos have assets, say, in the Cayman Islands or BVI or elsewhere offshore, then that could be another tool in the toolkit where perhaps you could get recognition under the common law standards that were discussed in the prior panel. So I think that's just a good example, as you're saying, where you bring the best of the jurisdictions together in a way that gives you a very powerful sort of multi-jurisdictional approach.
If I may add, Fabiano, just one topic. And the thing is, in insolvency cases, it might be easier to enforce foreign decisions abroad, even in Brazil, than in an ordinary litigation case, in the civil procedure case. Usually, enforcing foreign decisions in a regular civil procedure case can be a nightmare. I mean, the long run you need to go until you get a final decision. Sometimes even in the US, they demand a final decision in order a foreign decision to be enforced. You demand ratification and a number of steps that need to be taken, and you can just have a shortcut sometimes in an insolvency proceedings, even through a Chapter 15 and other remedies in Brazil.
That's quite powerful. You want to comment on a case that you had with view piercing?
Yes, thank you, Fabiano. Another interesting case that shows a little bit the differences between legislation is the Mina Tucano case. It's a mining company in Brazil that filed a judicial organization here in Brazil. I also had a client in this case, and they had a part of the creditor that was secured by a pledge of an account sitting in New York. And the debtor decided to seek recognition through Chapter 15 in New York, with the goal of having the collateral released by the court, by the Chapter 15 court, and replaced by another collateral. In this case, they offer equipment instead of the money sitting in the account, which is interesting because in Brazil, the debtor cannot simply request the court to replace a collateral during an RJ proceeding. The creditor must agree and authorize the release of the respective collateral so that the debtor can carry on and use the money or whatever or collateral we're talking about. In this case, they filed the request. From what I understand, and Dan can comment on that if he wants, but from what I understand, that's quite common in the US, in the Chapter 15, to request the release of a collateral, provided that there is adequate protection of the respective creditors. So the party must prove that there is adequate protection of the secured creditors so that the court can grant this request. And in this case, and I'll just talk about the part of the difference between the legislations. I was a witness of Brazilian law in this case, and the judge during the hearing, she asked specifically about this issue about our law, like, but can a judge simply replace the collateral? And I said, no, that's not allowed by our courts. And she was also a little bit confused because she said, even if I do grant this order and replace the replacement of the collateral, then I don't think that the party will be able to enforce that in Brazil. Because probably the JR court will not allow that, because she was supposed to render this decision and actually establish a new collateral that would not be possible under Brazilian legislation, which was quite interesting. Unfortunately, in this case, the debtor decided to suspend everything, so there was no decision issue, but during the hearing, the judge was very, clear about it, and she said, I'm not comfortable about granting this decision because I see an issue and a clear conflict with Brazilian law. So at the end of the day, we had an agreement. It was great, but I got curious to understand how the decision would go in this case. So it's another interesting cross-border case with conflicting legislation as well.
You want to come? No. Thanks, Liv. We've got a last topic we're running towards the end here, which is quite recent and a very interesting and controversial debate, which are the third-party releases in US Chapter 11 and Chapter 15s as well, right? We had a decision. It was a widely expected decision on the Purdue Pharma Sackler family case on June 27 by the Supreme Court, and we went through the decision, and it's interesting to see the dissenting vote from Justice Kavanaugh. I hope I'm pronouncing that right. And just gonna quote it very some of the phrases he wrote. It's pretty interesting. He says, "Today's decision is wrong on the law and devastating for the more than 100,000 opioid victims and their families. The court's decision rewrites the text of the U.S. bankruptcy court." And then he says, "As I see it, today's decision makes little sense legally, practically, or economically. It appends the carefully negotiated Purdue bankruptcy plan and the prompt and substantial recovery guaranteed to opioid victims and creditors." So, Dan, do you want to comment on that? Pretty controversial and a very difficult, fascinating dilemma, right? On how to treat non-consensual third-party releases, right, in bankruptcy proceedings.
Yeah, I would say that the decision in Purdue Pharma, which held that non-consensual third-party releases in U.S. bankruptcy proceedings are illegal, was anticipated, just given the makeup of the court. Although it's interesting, we heard a passage from Justice Kavanaugh, who was one of the most conservative justices on the U.S. Supreme Court. He was actually aligned with some of the most liberal judges on the U.S. Supreme Court in dissenting, because there was a long history in the United States through bankruptcy proceedings, through the creativity of the bankruptcy lawyers and the bankruptcy judges to use U.S. bankruptcy court as a forum to resolve these very messy, large-scale litigation problems, typically arising in the mass tort context. And in this case, at Purdue, it related to opioids, which had just a terrible impact on many communities in the United States. But getting to the point for these discussions, with the Purdue Pharma decision, a lot of cross-border restructuring and insolvency professionals are considering whether in the years ahead there'll be a greater appetite by companies and their investors to look for jurisdictions that may embrace third-party non-consensual releases and seek to effectuate the restructuring elsewhere and have it recognized under Chapter 15. That does bring up the question, though, is that when or if these releases are approved in the foreign jurisdiction, will there now be litigation within the Chapter 15 case over whether the court should recognize it in light of the Purdue Pharma decision? My own view is that, consistent with the text, consistent with the cases and the policy of Chapter 15, that those releases should still be approved under Chapter 15 because it has been recognized that simply because there's a difference in the results between U.S. bankruptcy law and foreign bankruptcy law, that's not a reason to deny recognition and enforcement of a foreign court order. So I think that, particularly in the case of LATAM restructurings, notwithstanding the view by many that Chapter 11 offers, perhaps a better route, I would say that there's going to be greater consideration now over whether, particularly in these cases surrounded by litigation, whether it's better to do it elsewhere and then come back to the U.S. through Chapter 15.
We'll see, right? Pretty interesting. Marcelo, do you want to comment a bit on how about the validity of third-party releases here in Brazilian proceedings and JRs?
Just a question for Daniel. If I understood correctly, the third-party release in the Purdue case, and by the way, there's an excellent Netflix series about the Oxycontin and the Purdue family, but the third party would be in exchange, in consideration for $4 billion upward investment from the family in the company.
Correct.
So the U.S. Supreme Court decision, the debtors did not receive this amount of money because the third-party release was considered void or somehow illegal?
A condition to the Sackler family putting in, I think, $9 billion spread out over time was getting a release not only by creditors who accepted the plan, by creditors who rejected the plan.
So that's why the judge was upset about
yes, because
the outcome.
You had many families and their heirs that were relying on a payout from the settlement that now have to wait
That's
and
an
see
interesting
what happens.
The dilemma there is, and the criticisms is that the Sackler family had a lot of money elsewhere that was not being
I think that's
so they were not doing everything. So the dilemma is to accept a settlement that brings $9 billion to the affected parties,
I think the criticism,
or let them continue the litigation. And they will invest the $90 billion in the litigation, right?
Yes, because throughout the years and when they discovered, when there were the first settlements in which there was recognition of their conduct, the Sackler family withdrew more than $14 billion from the company. And then right now for the plan, they were willing to contribute $4 or go up to $6 billion. But the reasoning, on the other hand, is that you're willing to put in a lot, but should have been even more, so you should contribute more. So that's one of the reasonings for not granting the settlement as well.
which is, by the way, very complicated to have courts deciding whether the amount is enough or not on behalf of the creditors or debtors, which I understand there is an ethic issue around this topic, but maybe it's not very practical to have court deciding whether it's enough or should be more, how much more, whatever. But talking about the Brazilian, I think we have a very similar reality in Brazil. I mean, third-party releases with broad scope are very rare, and courts usually do not accept third-party releases in Brazil. They do if against the party that voted in favor of the plan. So assuming that the plan is somehow an agreement, so those parts that agreed to that agreement will suffer the effects of the releases, but not the others, even those that were not present, that were not attending the creditors meeting for any reason. So courts are very reluctant and usually do not accept the release of the third parties, which sometimes can create a lot of problems because sometimes the assets of these third parties are being used by the debtor itself. So the enforcement against third parties might affect the restructuring of the debtor itself sometimes because the assets you have been used among them. So I think we have a similar and more, I think it's more stable situation in Brazil, right? I think you agreed even that third-party releases are not accepted in general. You might have some exceptions, but I think that the case law in Brazil nowadays is more stabilized in line with the Purdue decision.
Well, I understand this issue has come up in the Samarco case, which involves the Vale Dam, with a lot of claims and disputes and parties involved. So I'm just, curious on this topic of what happened in Purdue. Is at all relevant to the issues going on in Samarco?
Yeah, I mean, on Samarco, the discussion on the indemnification for the damages of the dam break were somewhat isolated from the judicial proceeding when the shareholders agreed in the plan to put a cap on the amount of the obligations that the company would pay to the indemnifications, right? When they put a cap and they assumed the obligations for themselves above that cap, that issue sort of went away from the judicial recovery process, but it's still a big discussion on what they call the repactuation, the resettlement, and how that will be done. And this is a challenging process that is ongoing right now, right? Well, how this settlement with all of these different entities will be done, and how to make it definitive, right? The shareholders and the company obviously wants a definitive position, but in Brazil you don't have that mechanism, right? The public ministry, the state attorney can have the individual right to raise an issue. So how do you do that on a definitive basis? I think it's an open question. And interesting that 3 weeks after the Purdue case, we had a decision on the Chapter 15 of Americanas, right? Granting the plan and which provided, among other things, broad third-party releases, especially to the shareholders. Right? Dora, you want to comment on that?
Yeah, sure. I think there's a major difference between the Purdue case and the Americanas case, because when the judge was deciding whether to recognize the Brazilian proceeding or not, there certain creditors, they brought to his attention that the option of the plan that provided for the third-party releases were almost coercive. I think there was an 80% haircut provided, and then the recovery ratio would be way higher than the other options in which there was not the third-party release. But then he deferred that to the Brazilian judge. He said, was there an issue of that pending before the Brazilian courts, and then said, no, there was not an appeal regarding that, the haircut amount of the options that provided for the third-party releases. So he said, I was worried about that. It came to my attention, but as there is no decision before rendered by the Brazilian courts that nullified that or recognized that the options were coercive, he decided to recognize the decision even so. So I think that shows what Dan was just talking about, that the Purdue case decision might not have an impact on the Chapter 15s that might be brought up to the United States, because they tend to respect what was approved by the original judge and courts.
That's fantastic. We are running out of time here. I wonder if there is any questions. All right, Fabi. I think it's being recorded, so nobody wants to miss your voice.
I won't say half of the thing.
He's causing.
I assume it's been.
Fábio is impossible today. It's a quick question. I know that we are not future tellers here, and this is actually for the Brazilian attorneys and to Fabiano as well. Do you see any courts here in Brazil recognizing a foreign decision with a third-party release? And I'm thinking about the basis of the public order issue, right? Do you see that a court would consider this issue as a public issue and therefore not the court consider that the decision is not available for recognition?
I won't dare to opine on that.
I don't know. We're not future tellers, but I think that the precedent that Liv mentioned, in which there was the recognition of the ACC and its special protection in Brazilian law, might lead us to the answer, but we're still to find out that Brazilian, there are a few things that are protected and they're very special for Brazilian judges and players that tend to be considered above what's been recognized elsewhere. So maybe that might be a hint of what will happen, but I think it's just one case law. And I mean, lawyers are creative, so I don't know what might happen.
Yeah, I agree, Dora. I think that I'm not sure if it is a public order matter. I have my questions, but I think that courts would tend to recognize it as a public order matter because in Brazil, as Marcelo mentioned earlier, the third-party releases must be approved by the respective creditors. So I think it's very similar to the other precedent that I mentioned, and I think there will be a trend in this sense. But of course, I don't have a crystal ball, but it's a hint.
I was thinking exactly the same. I was just like, while Daniel was talking, I was just thinking about, should we ratify a decision like that? I think we should. My opinion, person, but I think there's far from being a public order issue. I mean, it's a claim. But there's always an ethic analysis, as we saw in Purdue. In many cases we saw in Brazil, there's always an idea of fairness beyond. So I think it will depend on the plan. If you have a relatively fair compensation for creditors, and that's only one part of the possibility, I think that Brazilian courts might ratify that decision if there is a fair treatment to creditors in general. I think that's a lot of subjectiveness, but it's how it works at the end of the day.
Fantastic. Any other question we have time for? We don't have time, actually, but... All right. I'd like to thank a lot Dan, Liv, Marcelo, and Dora. Fantastic panels and comments. Congratulations. On behalf of TMA, again, I'd like to thank you everyone for participating in this, spending this morning with us here. Was quite insightful for me. I learned a lot. This is one of the many events we are having every year. We at TMA Brazil have about 50 events per annum. So I would incentivize you to follow us, to join us, and come to the debates and the discussions. It's one of our biggest objectives to raise the level of the discussions and disseminate the best practices of our complicated and very challenging practice here in Brazil. So thank you, everyone. Special thanks to Kobre and Kim for helping us and leading this event here. It's been great. I'd like to call Sergio Aguiar from Kobre and Kim for the closing remarks. Thank you, everyone. Thank you.
So, hi everyone. So with this great discussion about Chapter 11 and 15, we conclude our panels today. Thank you everyone for coming in. I know that it's really hard to be a whole morning away from your desk with emails and calls piling up, so thank you. Thank you, of course, to our panelists and moderators for this great discussion, sharing their expertise and great war stories. And finally, thank you, TMA, again, for organizing this. Echoing what Victor said at the beginning, we are very happy with the opportunity to sponsor this event. We are a conflict-free cross-border disputes firm, and the topics that we discuss here today are central for the work that we have been seeing around. Not only because of their cross-border nature, but also because they require our multi-jurisdictional approach, combining legal and non-legal solutions. And just before we go, coffee is still served, coffee and snacks outside. The pão de queijo might be cold, but I think we still have hot coffee and delicious cake. So if you have a couple of minutes, I invite you everyone for one more coffee, and it's a great opportunity to networking and continue the conversation. Thank you again.